AQUINO, please rise. Ahea oko e ko ka aha. Nahe kuliana imua o kea aha ho kolo kolo ki e hano hano o ka moko aina o Hawaii. I naoi mai, e malio mai, I lohi ia kaleo. Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. Inoho ilalo. Please be seated.
Please call the case.
Case number SCWC-22-0000499. State of Hawaii, Petitioner Plaintiff Appellee versus Alexander AQUINO, Respondent Defendant Appellant. Arguing for Petitioner State of Hawaii, Charles Murray. Arguing for the Respondent, Alexander AQUINO, Herman Heimgartner. Argument on the merits.
All right, good afternoon. Aloha, everyone. Today's proceedings is being broadcast live on the Judiciary's YouTube channel as well as on Olelo. And I'd like to welcome our substitute justice, Judge Rowena Somerville. Counselor, are you ready to proceed? Yes, sir. All right, we've allocated 30 minutes for each side. And just to confirm, Mr. Murray, you'll have 25 minutes for your opening argument. We'll give you a warning 25 minutes in with 5 minutes for rebuttal. Mr. Heimgartner, 30 minutes with a 5-minute warning. Please proceed.
Good afternoon, Chief Justice Rechtenwald, Justices of the Hawaii Supreme Court, Mr. Heimgartner. In this case, the ICA committed 2 grave errors issuing its decision on October 6, 2023. First, the ICA gravely erred in holding that the charges against Mr. AQUINO were insufficient. In short, the ICA erred on this issue by ignoring this court's holdings in Sheffield and Flores that restrain alone is the conduct element of unlawful imprisonment in the first degree. The ICA then committed further and greater error in holding that there was insufficient evidence to support AQUINO's conviction of unlawful imprisonment in the first degree, as well as that the trial court's findings of fact 15, 16, 17, 26, and 27 were also in error. The ICA erred here by substituting its evaluation of the evidence for the courts, the trial courts. Its judgment of the credibility of the evidence and witnesses for the trial courts. The ICA further erred by failing to follow the standards enunciated by this court, that evidence should be viewed in the light most favorable to the prosecution, that the question is whether there was substantial evidence as to each material element in support of the trier of fact's conclusions, and that the reviewing court must consider all the evidence adduced at trial to make such a determination. The ICA did not do that. The ICA picked details it preferred and replaced the ones that the court had relied on at trial. Because of the sufficiency of the evidence issue has far greater implications for the case, I will address it first. What must the state show to convict someone of unlawful imprisonment in the first degree? The charge draws largely from the Model Penal Code in Hawaii. And the Model Penal Code commentary notes that for unlawful imprisonment or the equivalent, it's unlawful restraint and circumstances exposing a victim to a risk of serious bodily injury that are the 2 key elements that must be proven. There's no dispute, either in the ICA decision or even by the defendant, Mr. AQUINO in this case, as to the sufficiency of the evidence on the element of restraint. There's no argument presented by Mr. AQUINO's opening brief at the ICA, and there's nothing in the ICA decision that calls into question the sufficiency of the evidence as to the element of restraint. In fact, Mr. AQUINO didn't even challenge the sufficiency of the evidence as to whether the restraint LR to the risk of serious bodily injury. What Mr. AQUINO challenged was that the state failed to prove Mr. AQUINO knew that LR was exposed to the risk of serious bodily injury under the circumstances. But contrary to AQUINO's claims, the state is not required to prove that the defendant knew LR actually suffered serious bodily injury. Just that LR just that Aquino knew that LR was exposed to the risk of serious bodily injury under the circumstances surrounding the restraint.
Is there a sort of issue of causation or speculativeness in the state's theory? In other words, the state has to, I guess, hypothesize that the complaining witness would jump again. I guess is that the heart of your theory? And the ICA seemed to thought that we went a bridge too far. What's your response?
What is the important point of inquiry is the circumstances surrounding the restraint. If on the one hand, the restraint had led the victim, LR, to attempt to escape by climbing down a 17-foot porch before, it was completely legitimate and realistic to imagine that those same circumstances being continued could lead to him trying to escape that way again. And the cases, Flores in particular, but also other cases, Burke and Hurley, which are from New Hampshire and Wyoming respectively, have looked at whether or not the method of restraint has to directly cause the risk of serious bodily injury, or at least how the method of restraint relates to the risk of serious bodily injury. In Flores, this court noted that the presence of a gun accompanying a restraint could meet the element of placing someone in risk of serious bodily injury. In Hurley, it was the defendant locked the victim in a hotel room, and then other individuals, including the defendant, engaged in beating up, for lack of a better word, the victim after he had been locked in the room. And the court in Wyoming said that under those circumstances, the locking was what put the victim in the situation to get beat up and thus exposed to the risk of serious bodily injury.
Counselor, if I may ask you, it's not just that the fact that the child was chained, he was actually confined to that outside area that had no way to get off other than he's going to jump or fall off, correct?
That's correct. He was, even when he was let off the chain during the day, at times, he was not allowed, per Mr. Aquino, in the house. And when Mr. Aquino would find him in the house, he would yell at him or even slap him.
You know, what I wasn't able to determine from the record was, what was the dimensions of that lanai that was 17 feet, which is almost 2 stories off the ground?
Yes.
How big was it?
The actual lanai itself?
Correct.
It was a fairly narrow, there are photos in evidence at the trial court level. It was a fairly narrow space, probably 5 feet wide at most. It was longer than it was wide. From the photos, it looked like LR could lay down and then have maybe a couple feet on his side before he got to the railing.
Would his feet dangle off the edge if he got that far over?
No, I don't believe so.
Thank you.
You know, the ICA is saying, the chain, the length is about 6 to 7 inches or so. Didn't stretch to the edge of the lanai where there was the 17-foot fall. How does Aquino know that that exposes the minor to a risk of serious bodily injury?
Yes, the state's argument and the trial court's findings were that Mr. Aquino knew because of the 2020 fall. Once the evidence at trial was that LR fell. It's unclear if Mr. Aquino knew. There's no evidence to show that Mr. Aquino knew why LR fell. There's no evidence that LR ever told Mr. Aquino why he tried to climb down the porch. I believe Mr. Aquino had referred to it as jumping off the porch at one point. But what Mr. Aquino did know was that LR, one evening after he was let off the chain to eat dinner, and before ostensibly he was going to be chained back up for the night, as it happened every day and every week preceding, LR fell off the porch. He was trying to climb down or jump down and he fell. Mr. Aquino was the one who found LR on the ground, injured. So injured that Mr. Aquino had to help LR back up into the house. So injured that Aquino didn't bother to chain him up for another month. Now, the state would argue that there's a reasonable inference that can be, 2 reasonable inferences can be taken from this fact and this knowledge of Mr. Aquino. First, that Mr. Aquino knew that LR might try to jump off the porch to escape, especially as it's getting closer to him being rechained up in the evening. The other thing that you could reasonably infer is that Mr. Aquino would know that LR could get really hurt, so hurt that he couldn't even get back into the house. But there's a third reasonable inference, I think, that could be made that the trial court itself might not have even made, but that by not chaining LR up for a month, not only did he recognize that LR was seriously injured, but Mr. Aquino directly recognized that it was the chain that led LR to jump off that porch, that the chaining was tied in to the reason LR fell off that porch in 2020.
Let me ask you this. I mean, is there also possibly a theory that just chaining somebody around the neck for long periods of time may, in certain circumstances, expose that person to a risk of serious bodily injury?
Absolutely. I believe the court has noted in the past that restraint, one way restraint can be shown is that it causes or exposes someone to bodily injury just in the form of restraint. I would argue that chaining someone around the neck, where they only have 6 to 7 inches of movement, definitely puts them at risk of serious bodily injury alone from the chaining. They could have their circulation cut off in the middle of the night if they rolled over while they're sleeping, because LR had to sleep like this. That's one thing I don't think the ICA really contemplated in their decision. LR was sleeping like this. Yes, LR's testimony was that he never got hurt from the chain, that he was able to lie down in comfort, quote unquote. But that didn't obviate the risk that was still present. Just because it didn't happen didn't mean it couldn't happen. And I would agree with you, Your Honor, that just chaining someone around the neck with a metal chain, a 14-year-old, could put them alone at the risk of serious bodily injury. But there was even more than that in this case. There was more than that the trial court relied on in reaching its decision. But in spite of that, the ICA ignored that and harped on one line from finding of fact 15, that when LR fell in 2020, he was being chained up. The ICA took that and didn't apply the most logical application of the phrase that this was during a period in which LR was being chained up, which is what the evidence showed. The ICA instead said that that was a clearly erroneous fact because he couldn't have been chained up when he fell. Because as the ICA, I would say callously points out in its decision, LR only had 6 to 7 inches of movement while he was on the chain. So it was impossible for him to fall off a 17-foot porch. I'm not sure a statement has ever been more literally true, while at the same time missing the point so spectacularly as that statement that the ICA made in its decision. Yes, LR was not chained at the time he attempted to get out and off the porch in 2020. And there's no dispute to that. But the fall was during a period in which he had been chained up every night in the weeks prior. The fall happened at night after dinner, right before ostensibly he was going to be chained up again. Now, LR said that it was an impulse. He doesn't even know why he jumped off the porch. But a reasonable inference could be made that LR didn't want to get chained up again, which led him to jump off.
Counsel, can I ask you, and I did read that part, and I know that one finding of fact could be read the other way in that it happened during that period of time that he was subjected to being chained every night. But wasn't there another piece of evidence, or at least in the declaration from the officer, where the child had used the bathroom in his pants, and the father had said that the kid thought he was going to get lickings from him, and he ended up jumping butt naked off the porch? And that was while he was confined to the outside porch area or lanai area?
That was Mr. Aquino's interpretation, from what I recall, as to why LR might have jumped off the porch that night, yes.
It was clearly due to the fear of the father.
Yes. Repeatedly, not just from the chaining, but over and over again in LR's testimony and in the facts in the case from other testimony and evidence, LR was clearly in fear of his father, or Mr. Aquino.
And whether he was chained or not, he was confined to that space outside. In fact, he couldn't come into the house to use the bathroom unless he asked for permission and they unlocked it and allowed him in. Is that what the evidence was?
That's correct, Your Honor. And that I believe also evidence came out that there had been a camera to watch LR when he used the bathroom, even when he was allowed in the house.
I'm sorry, could you repeat that?
There was at trial, there was evidence that came out that there was a camera that had been installed in the bathroom.
Thank you.
Now, the ICA, other than pointing out the flaw in finding of fact 15, the ICA offered no analysis or explanation as to why they invalidated finding of fact 16, 17, 26, or 27. And finding of fact 16 in particular is most concerning, why they made the decision they did. In finding of fact 16, the ICA noted earlier in its decision that LR had told the defendant, Mr. Aquino, he didn't like being chained up. And that's all that finding of fact 16 addressed. That even after being told that LR told Mr. Aquino he didn't like being chained up, the trial court said in finding of fact 16, the defendant and Ms. Aquino continued to chain LR up. That was all finding of fact 16 was. So it's unclear why the ICA decided to invalidate that along with the other findings of fact.
Counsel, why isn't this a Jardine situation where there should have been more specificity?
In terms of the
given?
charge?
Yes. Why doesn't Jardine apply here? Because the issue they're raising is to the restraint.
Well, with regards to the restraint and the Jardine issue, in this case, the means of the restraint is not part of a category like restraint is not a category of offense of items like substantial bodily injuries. There's many different kinds of substantial bodily injury, but they're very specific.
Could you lift the mic towards your, thank you.
I'm sorry. There are many different types of substantial bodily injury, but only certain things can be substantial bodily injury. In restraint, when you're talking about forms of restraint under the charge, there's almost unlimited numbers of things that could potentially qualify as a method of restraint or conduct that would restrain someone, much like physical abuse or animal nuisance, for instance. However, the reason Jardine shouldn't apply in this scenario is because there is no species from which to descend down to specifics. Restrain, when you're talking about the means of restraining someone, the means doesn't become an element. It doesn't become something that has to be defined in the charge.
What about the whole portion of the statute that refers to consent? If the complaining witness is under 18, there has to be it has to be without the consent of the parent. So that seems to be omitted from the charge altogether. What's your response to the suggestion that made this charge deficient?
That subsection of the restraint definition didn't apply here. And I think this also goes to a bit of Your Honor's prior question. In this case, there were two charges originally, only one of which Mr. Aquino was convicted of. But the other charge was that as someone who had lawful custody over LR, he failed to act in accordance with his duties to provide care and food and medical treatment and whatnot. So count two.
How did he have lawful custody?
He was LR's adopted father. He was married to LR's mother. And
He adopted him? I thought
I'm
he was a
not sure.
stepson.
That's
a totally different
There's nothing in the
situation.
evidence that said he adopted it. That was the information that the state had originally been operating on, but there was nothing submitted at trial indicating whether or not LR had been adopted by Mr. Aquino. But Mr. Aquino acted, as far as the evidence did show, as if he was LR's parent. At least that was the argument the state made when it charged the case. So he was charged as if he was the parent and custodian of LR. And he was charged via information.
He's parent, custodian. What is custodian? Is it a legal custodian?
Legal custodian in loco parentis. That was from the state's standpoint, when the case was charged, it was assumed that Mr. Aquino was acting in loco parentis for purposes of LR. LR lived with.
So it is, I just want to make sure I understand it. Is the state's argument that under that subsection, a step parent would qualify even if they're not married to or they haven't assumed some sort of guardianship?
That did become an issue, and that was why the trial court did not convict Mr. Aquino of count two, because under, I can't remember the statutes in 561, I want to say. Anyway, the step parent only becomes responsible if the mother or the biological parent is unable or unwilling to provide for a minor. And in this case, that was an issue at trial that was litigated and that the court ultimately found the state failed to prove beyond a reasonable doubt. But the point as it relates to the definition of restraint was the information available to Mr. Aquino in the information charge was that he was being charged for restraining LR, and he was also being charged for failing to provide LR with the necessities that were owed to a child in his care. Taking that together and viewing the information or the charge as a whole should have put Mr. Aquino, and most certainly did put Mr. Aquino on notice that what the state was pursuing was not a charge of restraint because he lacked the consent of LR's mother, who was also charged separately, but that Mr. Aquino was being charged for restraining LR by force and threat. And he further knew that because the information was filed, as was a declaration which detailed the method of restraint.
Getting back to the Chief Justice's question, 707-700, the definition of restraint has 1 and 2, and in between them is an or. I take it you believe it's wrong for the IC to treat that or as an and therefore that first prong really does not require a lack of consent, to criminalize the restraint of somebody by force, threat, or deception.
I apologize if I misunderstood. Yes, Your Honor, that is what the state's position is. The or is clearly, it could be this way or this way. It doesn't have to be this way and this way if the person restrained is under the age of 18.
In other words, if it was a alleged consent of a parent situation, it could be without force, threat, or deception.
If it was someone who did not have custody over a minor, yes, it could be without the consent of the parent. They could restrain them.
So in other words, a parent cannot consent to exposing the minor to a risk of serious bodily injury by threat, force, or deception in any situation.
Absolutely. The parental discipline defense is not available in situations like that, so it would make no sense for the legislature to allow it to be available in a situation in which a method of restraint also exposes the minor to the risk of serious bodily injury.
And therefore, given that the ICA's analysis was incorrect.
Yes, and befuddling as to why they spent so much time focused on that element without even addressing the other aspect of the restraint.
And if consent was not an attendant circumstance element, then there's no problem with not embedding a definition of restraint in the charging document.
Correct, because it didn't apply, and it couldn't apply to Mr. Aquino, at least when the state charged the case. And restrain.
So why did the state include the allegation that this was a minor?
That was because we were using his initials, and in accordance with the rules of filing, the court record rules.
I'm sorry, that was because of what?
The court record rules, I believe it's Rule 9, requires when if you're using initials to explain why and provide the birth date of the minor. That was the only reason why that was included.
Sorry, was this charged in circuit court or in family court?
It was charged directly in circuit court via information.
So can you, what is your reading of subsection 2? So if the person's under 18, so it's some kind of restraint other than force, threat, or deception?
Subsection 2, as best as the state could envision, would be a situation in which someone takes a minor, and restricts that minor's movement without the consent of their parent. When would that apply? When, for instance, could a person who's not a parent restrain a minor? A teacher, a school official, a coach for a little league. Those are situations where the minor might be restrained without force, threat, or deception, but still in a way that their liberty is restricted or their movement is restricted, but with the consent of the minor's parent.
So to clarify, those are the situations when there is not the subsection 1 threat of force or deception.
Yes. If there ever is a restraint by threat, force, or deception, no matter who's the restraining party in the state's position, that meets the definition of restraint for purposes of unlawful imprisonment in the second degree, unlawful imprisonment in the first degree, or kidnapping.
And tell me about unlawful imprisonment in the second degree that you didn't mention, because doesn't that have an affirmative defense in it?
That is correct, yes. And I'm sorry, I didn't brief unlawful imprisonment in the second degree, but from my memory, yes, it has a defense in it that might apply otherwise.
No, I wasn't calling you out. I'm not mentioning that, but you just had reeled off kidnapping. I think there's three offenses that this definition of restraint may or may not impact. It's kidnapping, unlawful one, unlawful two.
Oh, yes, absolutely. It applies, the definition of restraint applies to all three, and they all three descend from the same model penal code lineage.
So if we accepted the ICA's analysis here, that would affect kidnapping offenses or no?
Yes, it would. It would mean every kidnapping offense, such as the one in Sheffield that this court reviewed, would have to have the definition or sub-definition of restraint involved. But that's not what the court said in Sheffield. In Sheffield, the court was very clear that restraint was the conduct element. And what's interesting too is if you break it down into two subsections, then the second subsection is an attendant circumstance. It's an attendant, and that's fair. It's an attendant circumstance to conduct. But the first section, it's conduct. It's still just conduct by threat, force, or deception. That's something the acting party, the defendant, controls. It's not something that's outside of his control. It's not an attendant circumstance.
Help me understand something. In terms of the second definition of restraining, if a person is under 18 or incompetent without the consent of the relative person or institution having lawful custody of the person. So basically under that, a person with custody or a parent could consent to restraint that exposes the minor or the ward to the risk of serious bodily injury?
By the plain reading of the statute, perhaps, as long as the restraint wasn't by means of threat, force, or deception.
Well, the restraint isn't the crime in and of itself. It's the exposure to the risk of injury.
Well, that's the second prong of it. The restraint is the conduct, and the under circumstances exposing them to the risk of serious bodily injury is the attendant circumstance. So if a parent gave permission for someone to restrain their child and the restraint was not via threat, force, or deception.
Is that like if a parent were to consent to their child becoming an MMA fighter or something?
Perhaps karate, football. Actually, football would probably be a good example because there's dangers in football and you can get tackled.
I mean, doesn't it more fit the situation? Maybe maybe riffing off of one of your earlier type of examples where somebody without force, threat, or deception perhaps has somebody go into a child or minor go into a room. No force, threat, or deception. Parent says, yeah, you're able to take my child into this room. There's no water or anything in that room. I mean, these are oddball types of situations, but it seems to me that situation fits it a little bit more than exposing a child to the risk of, a sporting event.
Yes, that's probably.
And don't we have to, okay.
Yeah, it's whatever those scenarios are, they're very minute, and there may be other charges that would be applicable if the situation still exposed the minor to the risk of serious bodily injury. Thank you. Are there any further questions the state can answer?
Your time for rebuttal. Mr. Heimgartner.
May I please the court? Good afternoon, Chief Justice, Justices, and Mr. Murray. So Mr. Aquino raised 2 points of error, and the ICA ruled with him on both. And his position is that the ICA did not err. And so in the same order as Mr. Murray addressed the two issues, I'll address them, starting with the sufficiency of the evidence first, which is essentially a factual issue. And with the sufficiency of the evidence, I would respond and point out a number of things. So first of all, the the fall that happened in 2020, that happened when the minor was unchained. The testimony at trial was also that when he was chained, that the chaining did not cause him harm, did not scratch him. He was well fed. At night, he was let off the chain. On the patio, he had drawing materials, reading books. When it was raining, he was allowed to go inside. When he needed to use the bathroom, he was allowed to go inside. So the chaining by itself, the physical chain, did not cause injury or serious bodily injury. Now, with ICA's ruling, the point was whether Mr. Aquino knew that the chaining exposed the minor to serious bodily injury. Now, therein, it's serious bodily injury. It's not just any bodily injury, but serious bodily injury. And it also goes towards his state of mind. The state had to show that Mr. Aquino actually knew that. It isn't, was there a threat of injury? That's one question. But also the other question that the state had to prove was that Mr. Aquino actually knew about it. And basically, the court's findings was based upon the prior fall, approximately a year before, that made Mr. Aquino.
Are we bound by the court's findings, or if we were to reject the court's findings, would we still be able to consider other possible ways under which these circumstances would be likely to cause serious bodily injury? For example, what Justice Edens asked about. Just the fact that you have this metal thing around your neck.
Well, I would disagree. The court made specific findings. The court didn't make a finding that the neck by itself.
If a court in a criminal case makes erroneous findings, is this court able to consider whether or not those findings were harmless beyond a reasonable doubt?
I believe so. My argument in response would be regarding the chain, as I testified, there wasn't evidence that the chaining caused the risk. And I don't believe there was sufficient evidence that having the minor out on the patio exposed him to substantial or serious bodily injury, and certainly not that Mr. Aquino knew about it. The testimony at trial also was that the minor was out on the patio for a while before he was even restrained, because this was basically Mr. Aquino, his wife, they had an infant, and the minor, they lived in a one-bedroom.
Yeah, but they locked him out there. It was like solitary confinement for this kid. He's locked out there. They wouldn't let him in. He'd have to ask permission to use the bathroom. He had to eat out there. He's sleeping on the floor with just a blanket. It's almost 2 stories off the ground. He fell, or somehow fell off at one time, hurt his back. The stepfather said his back was messed up. He knows all of this.
Mr. Aquino.
And those are part of the circumstances of how he ends up out there getting chained up every night like a dog.
Well, I would agree that certainly bad parenting, but regarding the facts and the charge, it's whether the elements met that. It's not whether we agree with what was going on, but
he was restrained outside in that small area. You agree?
Yes, at night, but also the restraining.
Well, sometimes during the day, they would leave and chain him up.
There were occasions on that, yes.
Well, isn't it foreseeable, and that was Mr. Murray's argument, that if this child was, and maybe this is where you would argue the point, was so desperate that he would try to climb down or jump down on one occasion, he would do it again in the future?
And my response to that was the child testified he didn't even know why he jumped off the balcony the first time. He was unchained. They were having dinner. And so I believe that making that connection between maybe that was speculation, that wasn't a substantial evidence to support the finding.
Can't the child basically says, I don't remember why I did it, but doesn't the evidence support a reasonable inference that his confinement had a motivating factor in him trying to get off? I mean, it seems like a common sense inference, at least one could argue.
even the minor testified he didn't know why he jumped off. So I would say that I think, well, was there substantial evidence? I don't think that met the burden. I think the nexus between him jumping off and why he did that, it wasn't enough there.
What about your first argument?
Regarding the first argument, and that is the sufficiency of the evidence. So first, when it comes whether a charge is sufficient, the first thing we need to look at is when was a charge challenged? Because that determines the standard of review. In this case, the charge was timely challenged before trial by a pre-trial motion deadline, and so it's under right-wrong standard. It's not under the Motto-Wells standard. Under the right-wrong standard, the appellate courts look at the charge and whether it was correct or incorrect, well, whether it was right or wrong, whether it was sufficient or not. And then going to next, in looking at the sufficiency of the charge, and there's numerous cases on that, there's two specific things the appellate courts look at. First is whether a charge has all of the elements, and conjunctive, and whether the charge is clear. Now, regarding all the elements, the ICA ruled that one of the elements was missing without the consent of the parent or the lawful custodian. Now, with a missing element, that a charge that's missing an element cannot hold up. Nothing else and nothing outside of the four corners of the charging document can be considered. And that was the ruling in Blyenberg. Not the ruling, but there was comments on that in Blyenberg.
But to get to that point, you have to assume that the or is an and. I think Mr. Murray is saying there's two different ways for a defendant to violate the statute potentially, and one of which wasn't even argued here. That's the one you're talking about that wasn't pled. What's your response to that argument?
Well, first, the charge did not contain at all the definition of restraint. The charge didn't even make an inference to which subsection 1 or 2 of the restraint was alleged. The charge didn't say restraint under by force, by threat, or so forth. So looking at the charge, it didn't indicate whether it was restrained by subsection 1. And subsection 1 contains 3 different disjunctives within there: by threat, by force, or by deception. That wasn't alleged in the charging document. So,
But wasn't part of the charging documents the declaration from the police officer, Manser?
and I believe
and was that part of the documents?
no, the information charge is the information charge. Now,
Right. And in there, all they talked about as far as the restraint was the chaining of the young boy in the outside area.
well, the
They
information
didn't talk about parental consent or any of those issues, correct?
it didn't address the parental consent one way or the other, but the information charge also, there's information charge, there's also the declaration of the officer and then exhibits, but the charging document itself, the information charge, didn't indicate that. Also, there was a second count that Mr. Aquino was found not guilty on, the persistent non-support, but that didn't deal with consent or other issues, just whether there was shelter or I believe there was food or something provided to him.
In the ICA, in their footnote, they also said that where the subject of the alleged restraint is a minor incompetent, the state can potentially charge the defendant pursuant to either or both definitions of restraint. So they were aware at least that it's either or.
Yes, and my argument is the state in their charge should have been clearer. If they would have charged under subsection 2, then there's the element that had to be included. If it's under subsection 1, as this court has ruled recently, charging documents should contain, or could, and are, I think, recommended, suggested, to include to-wit clauses. A short to-wit clause with a few words would have clarified it and made it a sufficient charge that would stand up. But in this case, there was no to-wit clause, there was no definition, there was also...
But the officer in his declaration seemed to only be talking about force or threats.
And
as
that,
a means of restraint.
and that is to assume that the declaration and exhibits all become part of the information charging document.
Thank you.
And then going on, a couple more points regarding the sufficiency.
Well, can I ask you one thing? You know, I mean, you're not suggesting that just the normal layperson's understanding of what restraint means is that it's not a restriction of a person's movement. It's
No.
not what you're saying, right?
No, I think the normal definition would be restraint means to restrict a person's movement. The problem arises is because the statutory definition adds more and more. It adds subsections. It adds a consent issue. And that's a problem that I think Wheeler and these other cases have said. When a statutory definition doesn't comport with the ordinary understanding, then the definition needs to be included. So if we look,
But doesn't that comport with the normal understanding? And then I guess we get back to the two prongs, because if you have restraint and it doesn't concern consent, then I'm just having a hard time understanding how consent is an attendant circumstance that you need in there. And also, it's not like anytime there's a disjunctive that this court has required specifics. Now, it's recommended, as you mentioned, on the two wits, but for example, you know, TTs with dangerous instrument and all the various things. The fact that maybe one of the definitions of dangerous instrument isn't alleged, your theory by its logical extension means that it should be alleged. And I'm just wondering why on a disjunctive charge where the whole purpose is notification and providing the constitutional due process that the person knows what he or she is charged with, why in this situation you need to have both alternatives?
well, I think the state could have picked one too in the charging document. They didn't pick both. They picked neither and didn't provide any division of both. But even under subsection 1,
Was there anything under Van Vlienberg? We do say that it's everything that's provided up until the time that the charge is challenged. So as Justice Devins has indicated, the defendant had the information and all of the police reports. Was there anything in the police report said that we should be charging this because well, there's no way they could have charged under the consent because the mother consented. So everything that was provided to your client showed that it was by force, right?
well, and that only would cure, if there was a missing element, that wouldn't cure that. But with that, I also think that basic argument by the state, we gave all the police reports, it was a declaration, it was an exhibit. I think that's basically information dump to some degree on the defense. I think a charging document still should be clear and concise.
But that is not the standard of our law. Our law says that if there is a challenge to a sufficiency of a charge for failure to provide adequate notice, of course the defendant is entitled to notice of the charges. Then the court will consider the information that was provided up until the time the challenge was made. And in this case, based on the felony information, there was a lot of information that was provided as to what the nature of the accusation was.
And I would agree that, agree with that point. However, also, again, the information notice wouldn't cure if there's a missing element.
What missing element?
Well, the missing element that the ICA ruled upon.
And they are basically saying that if it's a minor, you have to show both force, deception, or threat, and that the parent didn't consent, right? That's basically what the ICA is saying.
Correct.
But the statute says or. And, you know, this these statutes are based on the model penal code. So I went back to look at, what the model penal code says. And model penal code starts with, they structure it a little bit differently, but they start with kidnapping. And when they talk about kidnapping, they say that that's the most serious offense. It's kidnapping and basically unlawful restraint. But kidnapping is the removal or confinement. They define it as removal or confinement, not restraint. We call it restraint. Must be accomplished by force, threat, or deception, or in the case of underage children or incompetence, without the consent of a parent or other appropriate person. And that only appears in kidnapping in the model penal code, right? And the unlawful imprisonment is defined a little bit differently. But when you look at that, it looks like our restraint definition looked at the model penal code and said, we're going to define it this way. The restraint is going to be force, threat, or deception, or in the case of underage children, without the consent of the parent. So in other words, it was always intended to be an or, not an and. Our case law says that our penal code is based on the model penal code. We will look at the model penal code. And it appears to me that the model penal code does not intend this to be an and. It's only intended to be an or. And as we have indicated, you can have parent consent to place a child in circumstances that have the risk of serious bodily injury that doesn't involve force, threat, or deception.
Well, my response to that would be first, the legislature in Hawaii has added and modified the model penal code. They have added this second prong.
If they didn't add it, they said or.
Well,
they didn't say and. They didn't say and in situation if it's a child without the consent. They said or.
I know, but we are talking also about the sufficiency of the charge. So the prosecutor, if they intended to charge under subsection 1, then they should have included that. Because if it would have been intended to be charged under 2, then there is an additional element.
Their argument is they weren't proceeding under 2, that everyone in this case knew all along that it was about 1. So can you explain to us why, if that's true, and you may disagree that that's true, it has to be that a part of the statute, which is just not even being relied on here, has to be further developed in the charge, even though that's not the charge that they say the part of the statute they say they're relying on. Why is that a problem in your view?
In my view, it's a problem because one of the it's disjunctive. It's an or, but one of the disjunctives has additional elements, and it wasn't made clear in the charge whether it was subsection 1 or subsection 2. And my argument is it should have been clarified.
Why? I mean, what your argument is that your client suffered some prejudice, or folks in general might suffer some prejudice, so we should require it irregardless of whether that's what's going to be proven or not? Or because I think implicit in Mr. Murray's argument is if they had suddenly halfway through the trial started arguing consent, that you could have stood up and said, that's your honor, this is out of bounds. This is not what was alleged, and we're on no notice of this.
And that's a very good question, but I would also point out at the start of my argument, I stated in a timely challenge, defendant doesn't have to show prejudice.
So my question is, even if it's not a theory that's relied upon during the course of the prosecution, it has to be alleged. That's your position?
Yes, and also especially considering that this was a timely challenge. This isn't a Motto Wells where there's a presumption that the charge was valid. The defendant doesn't have to show prejudice. And so it's a right or wrong as the appellate courts look at it.
So my question is, one possible sanction for not alleging it properly is that the state will be precluded from arguing that point later on. They can't argue part 2. I think their argument would be they adequately alleged part 1 because restraint is within the common vernacular of folks in the community, and they could proceed on that basis. But if they started getting into part two, that you would have had a good objection at that point. Why isn't that enough of a protection of the defendant's rights?
Well, because all the case law says that charges have to be correctly alleged with all of the elements. And the case law, I think, would state that the courts, I think, support timely challenges to charges. Charges should be sufficient. And it's in our Constitution that charges should be clear.
Even if it's an or, they
Well-
have to fully define both parts of the or. Both parts of the statute. Even if it's an or and they don't intend to go under one, they have to define the whole thing in the charge. That's your position.
Or clearly state in the charging document under what subsection they want to proceed on, which would have taken just a couple of words.
So, I mean, so your position is that essentially the state in this case had to allege and then prove beyond a reasonable doubt that the accomplice did not consent to this conduct?
No, that's not my argument, because the argument is sufficiency of the charge. The state should have clearly in its charging document set forth in a few words what
But
subsection.
that's what I mean, is that means you have to allege that this accomplice here consented to this conduct, which seems somewhat farcical.
No, because the state could have put in its charging document subsection 1 by force, threat, or deception.
Okay, so it's your notice. You're going back to your notice idea that you just didn't have notice on the charge?
Yes.
Okay, all right.
But the argument wasn't they have to prove that it's a charging language.
So
And-
your argument is the charge had to say by force, threat, or deception in order to give fair notice to the defendant that was a part of the statute that the state was proceeding under.
Yes. And then also one additional point I'd like to make, and this was also suggested in State versus Jardine regarding a proper charge. For a charge to have all of the elements, it isn't just a defendant that needs to have the notice, but as stated in Jardine, it's also, especially for a felony charge, it's either the grand jury or the court in a information charge or the courts in a preliminary hearing for basically the finder of probable cause at the start of a felony case to have the charge that was written by the prosecutor to make sure that evidence presented to them meets all of the elements set forth in actual information charge. So that was also referenced.
But doesn't Abalera also say you look at all the information that is provided by the state to the defendant? You look at all of it.
But in that case, the argument I'm making here regarding that is that basically this was an information charge. The court needs to have a properly worded charge so that the court, or if it's a grand jury, the indictment, that they look at all of the evidence in finding whether there's probable cause to support the charge and proceed with the case. In that case, it isn't just all notice to a defendant, it's also notice basically to make sure the grand jury or the courts had all the facts before them and determine what the elements were. Thank you for your time. I appreciate the oral argument. If there's any further questions, I'd be able to answer them. Otherwise, thank you.
No further questions from the court. Thank you, Mr. Heimgartner. Mr. Murray, your rebuttal.
First, I would note, law is that courts must review all the information provided to a defendant at the time they challenge a charge. And in this case, there was the information charge. There was the declaration attached to the information. There was a motion to determine voluntariness that quoted specifically the words of Mr. Aquino, where Mr. Aquino acknowledged that he chained up LR repeatedly. There was also a motion to revoke the defendant's, Mr. Aquino's SR, which quoted that as the reason for the charge. All of that was available to the defendant before he filed his motion to dismiss for an insufficient charge. And more importantly, and this I think goes to the discussion that was being had, the reason all essential elements are required for an offense per this court is to give the defendant fair notice of what he must face at trial and also to allow him to plead double jeopardy if it's appropriate. In this case, the defendant had more than fair notice. The defendant knew exactly what he faced at trial based on the declaration attached to the information, based on his own words to the detective when he was arrested. Okay, there's just like Van Bleinberg and Spratling and Treat, this defendant, Mr. Aquino, knew exactly what he faced at trial. He knew exactly what the state's evidence was going to be. He knew exactly why the state had accused him of restraining LR. It was not about consent. It was not even about talking necessarily on the porch. It was about chaining him around the neck. That was the fact that was listed over and over and over again repeatedly in the charging document, in the information, the declaration, everything that was given to the defendant.
What's your response to Mr. Heimgardner's argument that it would have been a simple matter for the state to clarify in the charge that it was only proceeding under Part 1 of the statute?
The state relied on this court's decision in Sheffield and Flores and other cases when it said that the conduct element for unlawful imprisonment in the first and second degree, as well as kidnapping, was restraint. This court said that was the element. It didn't say that it was restraint subdefinition A or subdefinition B. It said it was restraint. And the state should be entitled to rely on this court when it makes declarations about what the essential elements are for offenses. When the court issues rulings, we should be allowed to trust those rulings.
Can you try one more time on this argument? Just walk me through the argument.
Yes. The state should be allowed to.
His argument is all you had to do was say force, threat, or deception, then we would have understood you're under Part 1, wouldn't have to worry about Part 2. You owed that to my client. So what's your response? You say we've held that he didn't know that to his client. So please explain why.
This court in Sheffield and Flores and other cases said that the conduct element for unlawful imprisonment is restraint, not restraint by force, threat, or deception, or restraint without parental consent if the person's under 18, just restraint. The state should be able to rely on this court's decisions when it makes its charging and what it has to include in those charges. Thank you.
Thank you. Nothing further, I take it, at this time? All right. The court will take this matter under advisement. Thank you to both of our attorneys.
Iluna, please rise. Ua ho'oku'u ia mai ne kea aha ho'okolo ki eke hanahano o ka moko'aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.